I'm Beth Fraser from the Office of the Minnesota Secretary of State, and I want to thank you for your time today and for the opportunity to testify in regards to the proposed constitutional amendment that would restrict the right to vote to citizens who can present election officials at the time of voting a government-issued photo identification card. We are opposed to amending the Constitution in this way and to placing this language on the ballot for 4 specific reasons. First, the proposal would affect more than 700,000 Minnesotans, including current voters who do not have a current and valid state government-issued photo ID, and Minnesotans who use Election Day registration. I have a handout here. Looking at the bill passed last year as a guide, we have compared the Department of Public Safety Division of Vehicle Services database to the statewide voter registration system to determine the number of people who would have been affected by the bill passed last year, which required that voters either have a Minnesota ID card, a Minnesota driver's license, and that that identification have the voter's current address on it. We have found that roughly 215,000 registered Minnesota voters would fall into that category. These nearly 250,000 currently registered voters reside in every corner of the state, rural, urban, and suburban. We've been able to break out these numbers by legislative district, and they're being passed out to you now. The average is 3,200 current voters in each Senate district. Among the members of this committee, they range from 1,783 in Senator Kilash's district up to 4,140 in Senator Reinhardt's district. These voters, which include a disproportionately large number of senior citizens and young voters, would need to gather the right documents together and manage to get to the driver's license office, which may be, in some parts of the state, more than 80 miles away. If they are disabled, in assisted living, or a nursing or veterans home, they may find making the trip challenging, if not impossible. Many voters, particularly older women, are of an age where they cannot obtain a birth certificate in their maiden name and all of the legal documents related to name changes associated with marriage and divorce. There have been press reports of individuals ranging from elderly nuns in Indiana to lifetime employees of the Tennessee State Capitol who have been unable to get a state-issued identification. There was a provision in last year's bill that would have said that you can mail in a photo, but the Department of Public Safety has said that that is unworkable. People will have to go to the driver's license office in order to get one of these identification cards. I want to note that this figure, 215,000 plus Minnesota voters, only includes those who are currently registered to vote. It does not include any of the 700,000 Minnesotans who are eligible to vote but not currently registered, at least an equal percentage of whom are likely not to have an ID card with their current address. It does not include anyone who will become eligible between now and Election Day, or anyone who has lost their wallet. The requirement for identical verification standards would eliminate Election Day registration for the more than 500,000 voters who use it in a presidential election year. We have had Election Day registration in Minnesota since we have required voters to register to vote. We know that Minnesotans like and use it, and it's a key to our first-in-the-nation voter turnout numbers. So the proposed amendment would affect more than 700,000 voters, 215,000 without a current and valid state ID card, and more than 500,000 who use Election Day registration. Second, this amendment would place a major burden on our local election officials and our taxpayers. It would nullify Minnesota's current exemption from many of the onerous provisions of the federal National Voter Registration Act. Furthermore, it would require the use of provisional ballots, a type of balloting never before used in Minnesota, which local election officials have consistently pointed out would involve substantial additional costs and workload, most of it in vain, since nationally a huge percentage of provisional ballots are never counted. I want to note that the effective date would be nearly impossible to meet. If the enacting legislation is passed by the legislature in the spring of 2013, we would then need to revise the Minnesota rules to add information about provisional ballots, lay out the form that needs to be used, the procedures for processing them. We would need to replace the statewide voter registration system because it does not currently meet all of the requirements of the National Voter Registration Act. So there would be a lot of work that would need to go into implementation that could not possibly be done in 4 short months, especially since absentee balloting starts at the end of June. Senator McGuire talked about costs, and there would be substantial costs. Costs of providing the IDs, cost of outreach, cost of replacing the statewide voter registration, the cost of provisional ballots. Most of the costs would actually be borne at the local level. Third, we oppose this because the proposed constitutional amendment does nothing to address the only documented issue in our election system, that of those convicted of felonies voting before their civil rights are restored. The Election Integrity Task Force, of which Senators Chamberlain, Senator Sieben, and Secretary Ritchie are members, has come out with recommendations to provide additional notice to felons that they are losing their voting rights, and to provide additional data to election officials to flag those who should not be voting and to catch them if they do. Since IDs do not say whether or not you've been convicted of a felony, requiring IDs and doing away with Election Day registration will do nothing to address this issue. Fourth, the proposed constitutional amendment transforms voting from a right into a privilege. While many people have photo IDs, there are still significant portions of our community, like Senator Harrington's mother, tens of thousands of Minnesota senior citizens who do not possess photo ID, and obtaining one would be difficult at best and impossible at worst. The Constitution is the state's supreme law, and it should be used to protect the rights of our citizens, not to turn rights into privileges. Unlike a statute that can be easily modified to adjust to societal changes, the Constitution endures and is much more difficult to change. We should not be adding references to specific technologies such as photo ID that could go the way of the 8-track cassette. This proposal is simply a bad idea. Please protect the right to vote for over 700,000 Minnesotans and vote against this proposed constitutional amendment. Thank you, Mr. Chair.
Thank you. Ms. Idle, please.
Mr. Chair, can we ask questions now of witnesses, or do you want to wait till the end?
You have to ask questions.
Let's, if you can be brief, we'd like to keep them to 2 to 3 minutes.
I had a question for Ms. Fraser. Ms. Fraser, you made a comment about in some states provisional ballots aren't even counted. Could you tell me what states don't count ballots?
Ms. Fraser.
Mr. Chair and Senator Limmer, provisional ballots are counted only if information can be verified. And in the proposal passed last legislative session, voters would have been required within a few days after the election to go to their county seat or their city hall and provide identification that they couldn't provide on election day in order to have their ballot counted. If they either could not come up with the identification or could not get to City Hall or the county seat in time, their ballot would not be counted.
But Ms. Fraser, could you tell me what states don't count ballots?
Ms. Fraser.
You gave testimony just a few minutes ago that there are states that don't do that. Could you tell us what states those are?
Mr. Chair, Senator Limmer, I'd be glad to gather some information about the number of provisional ballots not counted in states around the country.
Okay. And Mr. Chair, Ms. Fraser, you made reference about addresses of student IDs. You know, we did have a bill just last year that introduced the policy of a voter ID concept in Minnesota. That particular provision did provide for student identification cards that have photos. Almost every school, as far as I know, have a photo on that card, and that could be used for a valid photo identification as recognized by the proposal we considered just last year. So we do have a model legislation that certainly has addressed many of the concerns that you've raised. And as for the cost factor, I think the cost factor was steadily being decreased as we got down to the end of the bill, and I think it was only a mere $2.5 to $4 million out of a $34 billion budget. So is there any new costs that you are aware of what that could be inflated to?
Mr. Chair, Senator Limmer, the bill passed last year had provisions related to using student IDs, but only for Election Day registration. The way that the bill read, it would have allowed you to use certain IDs to register, but it didn't change the requirements for voting. So it would be possible under the bill passed last year to show up at the polling place, provide proof of residence for Election Day registration, and then not be able to cast a ballot that would be counted because you didn't have what was required to cast a ballot, which was a Minnesota driver's license or state ID card with your current address on it. So it would have allowed you to register on Election Day, but not to cast a ballot that would have been put into the ballot box with everyone else.
Mr. Chair, I really didn't want to get too deep in the weeds of discussing a bill that we are trying to recall from a year ago. But the point is clear that the way the bill is written is that this direction, if the public decided to agree with the question and vote yes, would require us to fashion a photo identification requirement for voting as prescribed by law. It would be a future legislature that would create the mechanism, statute necessary to enforce the intent of the public. And so all of the discussion we're having about whether it's a previous bill that became, well, that got vetoed by the governor, or if it was any other example anywhere else in the country in the 31 other states that seem to have found that there's a virtue in identifying who the voter is by a photographic effort, all of these details would be required of the legislature to ferret out in the future. And so what we're really doing, and I know that we keep hearing this discussion of all of the pitfalls of a policy, technically the policy in its specific form has not been created, just like any other constitutional amendment that goes before the public. If we had a requirement to, let's say, limit what we spend money on in the state of Minnesota, that would also be by a prescription of law. If we decided to finance a Viking stadium through the use of a constitutional amendment, all those details could never be put in a little paragraph on a question. That would be allowable for the legislature. It would be a green light for the legislature to make that plan. So I would venture to guess that there's probably going to be a lot of critics here waving a lot of red herrings about a bill, but really the bill is the bill right before us, and the focus is on the question that we'll be giving to the public.
Mr. Chair.
Ms. Fraser.
Senator Limmer, you asked about costs, and there are additional costs in this proposed constitutional amendment in that it would eliminate Election Day registration, which would require quite a bit of modifications to our current system. It also nullifies our current exemption to the federal National Voter Registration Act, which would require us to treat voters very differently, to send significantly more mailings. We would basically need to replace the statewide voter registration system, which has cost at least $10 million in development.
Mr. Chair. Mr. Chair.
Nelson.
Mr. Chair, thank you. My question was also to Ms. Fraser as well about provisional ballots. I found that rather unusual testimony to say that provisional ballots don't work. I'd like to know how many states have provisional ballots. And then just to further, in your testimony, I found it hard, it was kind of incongruent to say that, well, we don't want to amend the Constitution because the Constitution is difficult to change. Well, we're very glad the Constitution is difficult to change, but it works both ways. It's just as hard to change the Constitution with the proposal we have before us as it would be for citizens at some later time to change the Constitution again. So I do find that kind of a red herring as far as an argument. And the other thing that I found interesting that was nothing I had heard in your testimony prior, and that was the issue about the Senate File 509 that was passed last year and passed in the House and vetoed by the governor. Did have that provision in there about students being able to use student IDs to vote. But your testimony today, you said that that bill would allow such a student to register but not cast a ballot. And I just don't recall you mentioning that when we discussed this in great detail last year. And I would think that that would be a very important issue. And of course, the intent would be if you are going to allow someone to register, you definitely want to let them vote. So again, I'm just find that kind of a incongruent argument to put forth at this point, and wondering why you didn't mention it a year ago or last legislative session.
Ms. Fraser.
Thank you, Mr. Chair and Senator Nelson. In terms of changing the Constitution, the concern is about putting specific technology in the Constitution and about requiring that voters present photographic identification. I actually don't think that the law could say, no, voters don't have to show a photographic identification. Instead, we'll have them use a retinal scan if the Constitution says it has to be a photographic identification. So that's the concern, is about specifying technology in our Supreme Law, in the Constitution.
Okay, maybe, Ms. Fraser, are you going to be available when the committee has their discussion? They may want to come back to you with other questions.
Sure.
Why don't we do that?
Ms.
We'll do that. Can Ms.